Hi, so we've probably already spoken once. Perhaps you called my office and set up an appointment, or you emailed me, or you went online and set an appointment. That's all great. So what to expect, right? So here's what's going to happen going forward. When you come in, I'm going to give you an intake form to help me fill out some information, or perhaps you're going online and doing it now. Don't worry about not being able to provide all the information to me. That's fine. I used to do this face-to-face, and it'd take at least an hour just to fill out this worksheet. So the more you give me on this intake, the better off we'll be, and we'll have more time to spend talking about things that really concern you. So the first thing we'll do when you come in to see me is we'll go through this intake, the intake we're going to use to help prepare a bankruptcy petition. The bankruptcy petition is supposed to list all your income, all your assets, everybody you owe money to. My paralegal will take that intake, they'll start working on the petition. I'll give you a checklist of things I'll need back. I'll need to be able to document income. I'll need to get any creditors that may not show in the credit report or the judgment search. I don't need you to give me all the credit card information because I'm going to get that automatically. It's those people that don't show in the credit report that I'll need your help with. I'm going to probably need tax returns and some bank statements. If you own real estate, we'll need some sort of valuation, generally just from a realtor to give us a market analysis. All these things we'll work together on. You don't need to be overly concerned about it. Again, the more information you give me prior to us getting together, the more time we'll have just to talk and work through any questions you have and make you feel more at ease. So after that meeting, again, the paralegals will get to work. Depending on what kind of bankruptcy you're doing, depending on what paralegal you'll be assigned to, he or she will gather that information from you, start working on this petition, and then at some point, you and I will get back together. We'll look it over. We'll make sure it's okay. We probably would have discussed any potential concerns already, and then we'll get the petition filed. Now, if it's a Chapter 7 case, we file. 30 days later, we're going to go down to either Newark or Trenton or Camden in rare circumstances, and we're going to meet with the Chapter 7 trustee. The Chapter 7 trustee is going to ask you some very basic questions, things you don't need to be prepared for, right? He's going to ask you questions about, did you list everybody you owe money to? Did you disclose everything that you own? Your creditors do have a right to show up there. Don't be overly concerned about it because they almost never show up. If they do show up, it's something we probably know about ahead of time. At that meeting, you're going to be asked to be shown, you're going to have to show the trustee evidence of your Social Security number, usually with a Social Security card, preferably, and a photo ID, just to make sure that's really you. We'll be in a big room with a bunch of other people doing the same thing that day. Again, it's not at a courthouse, it's an administrative building. Nothing to be overly concerned about. It's not overly formal, it's hardly formal at all, and everybody's doing the same thing that day. At the end of that meeting, the case generally closes 60 days thereafter. You'll get a discharge in the mail, and the case will close in a few days, and you'll be on your way. Any debt you had prior to the filing, you no longer owe, with certain exceptions that we'll talk about. If it's a Chapter 13 case, it's a little bit different. Again, 30 days later, we'll go meet with that trustee. The trustee will generally ask questions about what's our plan going forward. Chapter 13 is a reorganization. You're not just walking away, we're reorganizing our debt. It may be because we need to get caught up on past due mortgage payments, or we have tax debt we have to pay back over time. Or there's some other reason why we want to reorganize, or some reason why we have to reorganize rather than just liquidating on Chapter 7. Your job is pretty much done after that meeting. In a Chapter 13 context, though, we're going to be involved, we're going to be in the court for probably years to come. You'll have to be involved with us only to provide us certain information, but you'll never have to go to another meeting. Your job will be done at that creditor's meeting other than providing us information going forward. But similar as a Chapter 7, at some point the case will come to an end. You'll get a discharge. Any debt you have prior to the filing will go away, with those certain exceptions that we could talk about another time. But that's really it in a nutshell. I don't want you to be, again, overly concerned, overly stressed. I know you're coming in to see me and you're already stressed out. Trust me, when you leave, you'll likely feel a lot better.